Appeals. This is the second case on our docket. Can you hear me okay? Okay, this is the second case on our docket this morning, and it's State v. Ackland. If the attorneys if the attorneys could state their name and their readiness to proceed, please.
Good morning. My name is Andrew Paulus. I am a supervisor.
You are muted, Mr. Paulus.
Hunter Siren, my colleague, is going to be arguing this morning. He's right here.
Okay.
Good morning, Your Honor. I'm Hunter Siren. I'm a certified legal intern practicing under the supervision of Attorney Andrew Paulus on behalf of the appellant.
Okay, thank you.
Good morning, Phoebe Cates for the City of Cincinnati, the appellee in this matter, ready to proceed.
Okay. So I will be keeping your time, and I think the easiest way to do this will be to put in chat when you have about a minute left of your time. Mr. Siren, would you like to reserve any time?
Yes, Your Honor. I'd like to reserve 2 minutes.
2 minutes? Okay. All right. Whenever you would like to get started, you may start.
Good morning, Your Honor. My name is Hunter Siren on behalf of the appellant, Mr. Brian Ackland. Given the numerous inconsistencies between the officer's trial testimony and the indisputable body camera footage, this court cannot be confident in this case's outcome. There are 2 issues before this court today. We have the manifest weight issue and we have the suppression issue. Looking first to the manifest weight issue, there are multiple instances where the indisputable body camera footage demonstrates that the officer's testimony at trial was demonstrably false. To give a few examples of this, first, I
had a question for you. Sorry to interrupt, but when you're talking about the body cam and the inconsistency with the officer testimony, like, we're on a manifest weight standard, so simply showing some minor inconsistencies isn't really enough to meet the manifest weight standard. So could you address how those inconsistencies, in your view, rise to the level that it would justify manifest weight limits?
Yes, Your Honor. So the issue with the inconsistencies, or where the body camera footage shows the testimony is demonstrably false, is that we only have two key pieces of evidence here. We have the body camera footage and we have the trial testimony. However, when we look at the trial testimony and we have these statements, for example, where the officer said they could smell Mr. Ackland, they smelled alcohol on him. But we see in the video, in the body camera footage, we see evidence that contradicts this or shows that that's not true. That's where Mr. Ackland's conviction rises to going against the manifest weight of the evidence. And because this court can't be confident in the outcome given.
Well, let me push back a little bit there. Like, how can we tell from the body cam footage that they couldn't smell alcohol?
Yes, Your Honor. So, for example, as I said, they testified that they could smell alcohol in Mr. Ackland and that he was slurring his speech. But what we see is in the first 4 minutes of body camera footage, they were ready to let Mr. Ackland leave with the citation for driving under suspension. And it doesn't follow that if the officers truly did smell alcohol in Mr. Ackland or believed he was drunk, that they'd be prepared to let him go with a citation for driving under suspension. So that's essentially where it's demonstrably false, because we certainly can't tell facially that they could smell alcohol on him or not, but we can infer from their actions that they couldn't, essentially. To give another example.
Well, let me ask Mr. Siren, I watched the body cam videos, and I didn't see any indication that the police were going to permit your client to leave after it was determined that, I think he told them he was under an FRA suspension for maybe some child support. But it's been my experience that when somebody is stopped for driving under suspension, the police just do not let him drive away. I mean, maybe he's free to walk away, but I didn't see any indication they were just going to let him go. Maybe I missed it, but I don't. Where is that on the body cam?
So, Your Honor, at about 3.5 minutes into the first exhibit, we see the officers conferring at Officer Owens Jordan's police car. And Officer Bailey asks her, and simply asks her, "Are you writing him up for suspension?" And she says yes. But at this point, if they had smelled alcohol on him and they heard Mr. Ackland slurring his speech, it doesn't follow that she'd be merely writing him up for suspension at this point. We would think they would
She
begin.
didn't say that. I mean, she didn't say she was only writing him up for that. Just because she confirmed that, yes, she was going to give him a ticket for having a suspended license does not equal her not writing him up for anything else.
I understand, Your Honor. It just doesn't follow that if they were writing him up for driving under suspension at that time, if they both suspected he was intoxicated at that time, you would think even during that private conversation, one of them would have at least mentioned to the other, "Hey, I smell alcohol on him," or "Hey, did you think he was drunk?" or anything. But we don't see any of that. And we don't see any of that for 12 minutes until Mr. Ackland's already in the back of the police car when Officer Bailey ironically says for the first time, "I can smell you from a mile away." We don't hear that for 12 minutes in the body camera footage. Thus, it doesn't follow that the officers suspected he was drunk as they testified, proving that their testimony is demonstrably false. And to give a final example of that, Officer Bailey testified that he saw an empty bottle of alcohol in the backseat of Mr. Ackland's car during his plain view search. But what we see, there's a couple instances or a couple takeaways from that plain view search that demonstrate that are inconsistent with his testimony. First, after Officer Bailey finished the plain view search, he asked Mr. Ackland for consent to search. Now, certainly if Officer Bailey smelled alcohol on Mr. Ackland, heard him slurring his speech as he testified, and then saw a bottle, it certainly doesn't follow that Officer Bailey would even feel the need to ask for consent. We would think that he would administer a field test or at least arrest Mr. Ackland for OVI at this point, but we don't see that. We simply see him ask for consent to search. And beyond that, when he does handcuff Mr. Ackland after asking for consent, all he mentions is that he sees a bullet. He mentions nothing about an empty bottle, and from the footage, we can't really see what's in the back seat. So at that point, it's unclear if he did or not. Thus, given that the body camera footage renders the officer's trial testimony demonstrably false, this court should either reverse Mr. Ackland's conviction or at the very least remand for a new trial that's not tainted by demonstrably false testimony. And there's an important point to note on this regarding this court's position reviewing Mr. Ackland's conviction for OVI in the manifest way. The specific nature of this case places this court in a superior position to the trial court to review the evidence and compare. Unlike the trial court, this court has a transcript, and this court has the ability to watch the body camera footage at its own discretion. It can.
Well, let me ask you this, because I think this raises some interesting issues, which is just because we can watch the body cam footage like the trial court, we're not supposed to be a fact-finding court. But does the fact that his body cam footage change the nature of our review? Does it, in your mind, mean that we should look at something more critically than if there were no?
Your Honor, I think this just provides this court with a unique opportunity to take the trial transcript and compare it directly and closely watch. And I think that if this court has the means to, it certainly should, because we want to be confident in the outcomes of these cases. And when this court's able to take the body camera footage, compare it directly to the transcript, and see that the body camera footage shows that trial testimony is demonstrably false in multiple ways, we cannot be confident in the outcome. Looking at the suppression issue, the trial court erred by failing to suppress the marijuana pipe that officers found on
Mr.
Mr.
Siren, sorry, I was muted
Sorry.
while I was trying to talk, but I have a question before you move on. Does the fact that there was about a 2-year gap between the arrest and the trial, does that make a difference here as far as why there might have been inconsistencies?
Your Honor, it certainly speaks to the officer's credibility and ability to recall, but that's essentially the problem. the trial court assessed the witness's credibility, but this court can assess under the manifest weight standard, it can assess the witness's credibility on its own based on these comparisons. And certainly the 2-year gap is further evidence that the officer's trial testimony is inconsistent because it wasn't fresh in their mind at the time if there was a 2-year gap between the incident and the conviction. If that answers your question. Looking at the suppression issue, the trial court should have suppressed the marijuana pipe that officers found on Mr. Ackland's person incident to an arrest that lacked probable cause. So at the suppression hearing, Officer Bailey testified that Mr. Ackland was under arrest for the gun, which the gun charge was later dropped, was under arrest for the gun at the time that he handcuffed him in the body camera footage, which is right after he asked for consent. However, at this point, Officer Bailey had only spotted a bullet and had not seen the gun. And it simply does not follow that Officer Bailey could arrest Mr. Ackland for a gun that he had not yet seen. Merely seeing a bullet is not enough to arrest for a gun, simply put. Yet after this point, we see him take Mr. Ackland back to the police car, search his person, and that's when he finds the marijuana pipe. Consequently, the court should have suppressed the marijuana pipe that it found incident to the arrest because the arrest lacked probable cause. Thus, the trial court should reverse Mr. Ackland's conviction for OVI or remand for a new trial that's not tainted by demonstrably false testimony. And further, the court should reverse the trial court's order denying the suppression order, and as the trial court should have suppressed the marijuana pipe discovered on Mr. Ackland's person. And if there are no further questions, I'd like to reserve the remainder of my time.
Okay, thank you. You have about 4.5 minutes left. Ms. Cates, whenever you are ready.
Thank you. May it please the court, Phoebe Cates for the appellant. I first wanted to address that this is a manifest weight issue. So while there are some benefits for this court, such as comparing the transcripts and the body cam and time to review all of that, it's really only in exceptional cases that this conviction should be reversed. And some minor inconsistencies in testimony is not enough to reverse this conviction. As the court pointed out, it was about 2 years since then, and overall the officers did testify consistently. There were some things like it being a wild, officers testifying that it was wild turkey bottle and then it was actually wild Irish rose. Inconsistencies like that do not go to credibility in this instance. It was a bit, counsel's arguing that because officers were in the process of writing a suspension, that meant that there was not going to be OVI added to that ticket. It would be the state's position that as soon as officers approached, and it was really he approached them, there's facts in the record that say he was driving at a high rate of speed, that he pulled over suddenly after squealing his tires, that officers got out without ever even needing to initiate that stop, and the defendant walked out. They asked for his license. He has trouble finding his license, in fact goes over it as Officer Owens Jordan is pointing to it, specifically saying, no, that's your license right there.
I think that those are all good points. I guess there is still just this incongruity where they don't seem to be focused on any sort of intoxication issue at the early stages of the investigation. And if he's visibly intoxicated or there's an odor of alcohol, you would have assumed that they would be zeroed in on that rather than that suspension license.
It would be the state's position that they that just because they're not articulating that out loud, saying, sir, there's clearly an odor of alcohol on you, sir, you're clearly excited, things like that. There are procedures that police officers often take before getting to that step, one of which is verifying the license, seeing if there are any warrants out for officer safety. That's kind of the first step that they take. And while Officer Owens Jordan is in the back, Officer Bailey is having that conversation with him. Multiple officers pull up as this is going on. And then he has this conversation with Mr. Ackland in which he says, yes, I'm under suspension. So Officer Bailey goes around and verifies that Officer Owens Jordan is writing a suspension ticket, and she is, and they have that conversation about viewing his car. There were, in addition to the OVI, there's this potential gun issue that was ultimately resolved in a different court, but they see a car of a similar make and model as that of a shooting scene that they just cleared. So there are some other concerns going on, maybe that didn't necessitate them directly addressing the OVI instantaneously. And in fact, when there's the bullet on the car, the OVI becomes not the primary concern at that point. So I think just because the officers are not articulating on body-worn camera, this is step one, this is step two, or doing it in an order that maybe defense counsel would like to see, doesn't necessarily mean that the OVI was not a concern at that point. And in fact, they articulated that it was, both in the motion to suppress hearing and in the trial. So it would not be the state's position that that wasn't an issue as soon as they met Mr. Ackland.
Ms. Cates, on page 17 of your brief, you say that upon seeing the bullet on the seat of the car, the officers were allowed to search the car. On what authority do you base that?
Base that on the plain view and the automobile exception. I did address that. I'm sorry, did you say something?
So a bullet itself, just a bullet?
I would say the bullet and the open container in the back of the seat. Both of those gave the officers the ability to search the car, in addition to the facts in which officers were talking about this is the same make and model car as the shooting scene we cleared just half a block away. That gives them the ability to search the car out of their safety. And the
simple existence of a bullet in plain view would not justify the search of the car. Do you acknowledge that?
It would. I understand what the court is saying. I think, again, in the bigger picture of the safety concerns and the scene before and the open container, all of that is what gave the officers the ability to search the car.
And so, but then that brings into question whether or not the officers saw the bottle of alcohol prior to the search. And it seems like it's a little bit unclear as to whether that occurred.
My understanding from what Officer Bailey testified on the stand was that he did see the bottle first, and that he started on that side of the car in the video, that he saw the bottle, he's shining his flashlight, and then he goes around, continues, and then he sees the bullet on the car. And that's what kind of changed this from an OVI to prioritizing the gun issue. But he testified that he did see the bottle, that he saw the bottle first, and that was where he found it. So the trial court found that testimony was credible and that was not an issue. And so while defense counsel would like to say that that's not the case, that's what Officer Bailey testified. And if this court agrees with the trial court's findings that Officer Bailey was credible, then that's what we're left to believe. So based on both the plain view exception and the automobile exception, that's what gave them the ability to search the car and detain Mr. Ackland. And so that would lead to the suppression issue that counsel is trying to raise. And it would be the state's position that that specific issue that defense counsel is trying to raise now was waived at the trial court setting. Specifically on page 5 of the transcript, defense counsel said that it was very clear that the officers had probable cause to arrest, and that would not be the issue at the motion to suppress hearing. There was very clear discussion on what the issues would be on the record, that it was a legal detainment, prolonged detainment. The state had asked defense counsel to narrow those issues, and he did so on the record. The state proceeded with that motion based on those issues. So it would be improper to now raise an issue that was explicitly waived on the record and ask the state to
You acknowledge these issues were raised in the motion, right? The suppression motion.
I do agree that they were in the actual motion. And that kind of led to there was an off-record conversation where the state asked the defense attorney to narrow the issues pursuant to Norwood v. Kahn. I did review the defendant's motion. It is what we would probably call a boilerplate motion with very bare bone facts, which is why the state had asked him to narrow the issue. And he did so on record, stating that there was, in fact, probable cause to arrest, and therefore there was no testimony at the suppression hearing about the probable cause to arrest or the ability to search. However, given everything that was put on the suppression record, there was probable cause to arrest or at least detain Mr. Ackland for officer safety at that point, which would result in the frisk of Mr. Ackland to determine whether the gun was on him or not, and led them to the eventual search of Mr. Ackland, which resulted in the crack pipe being found. So based on that, would ask the court to find that that issue was specifically waived, but even if not, that there was in fact probable cause and a search incident to his detainment. If there are no further questions, I will rest on the brief. Thank you.
Thank you, Ms. Cates. Mr. Siren, you have 4.5 minutes whenever you are ready.
Thank you, Your Honor. Just a couple points on rebuttal. The crux of the prosecution's argument about the manifest weight is the fact that the officers don't have to say out loud that they suspect that Mr. Ackland was drunk. But it's notable that throughout the first 12 minutes of the encounter, we don't even hear the cliche question everybody knows, "Sir, have you been drinking tonight?" or anything to that effect. We hear no mention of alcohol, despite the officers testifying that they could smell alcohol in Mr. Ackland from the moment they approached him. And there's certainly 2 instances where the officers would have smelled alcohol in Mr. Ackland. First, as the prosecution mentioned, when Officer Owens Jordan's asking Mr. Ackland for his license. She's standing in close proximity to him, talking to him, and he's talking to her. But we hear no cliche question, "No, sir, have you been drinking tonight?" or no mention of alcohol at this point. The second occasion is when Officer Bailey is interviewing Mr. Ackland behind his car. And this is the point where Mr. Ackland admits that his license is suspended to Officer Bailey. But again, we see them standing in close proximity talking to each other. And Officer Bailey testified that he could hear Mr. Ackland slurring his speech and that he could smell alcohol. But with them standing close, again, no cliche question at this time, "Sir, have you been drinking tonight?" or nothing to that effect. And then finally, based on their actions, when we see them do the plain view, if, as they testified, they believe Mr. Ackland was drunk at the point when they were doing the plain view search, the plain view search wouldn't have even been necessary. We would reasonably expect the officers to begin something along the lines of an OVI investigation through something like a field test, or again, simply asking the question. But we hear none of that.
Siren, does the fact that your client refused to take a test at the police station after repeatedly asking for a test earlier, does that factor into anything?
Your Honor, no, it does not factor into this, because anybody that was understandably detained and taken to the station, and as I believe he says in the footage, he was sitting there for around an hour. Anybody in that situation that might be understandably frustrated and may not want to take a test at that point. At that point, it's understandable that Mr. Ackland felt defeated and just was done complying with the officers, since they didn't seem to want to comply with him, since they wouldn't let him watch the search or anything to that effect. Now, the second point I want to address, Your Honors, is that this issue on suppression about the marijuana pipe was not waived. Mr. Sinclair at the suppression hearing waived the issue regarding probable cause to arrest for the gun. But the gun was not discovered at the point that the officers discovered the pipe on Mr. Ackland. They had not yet discovered the gun. Thus, it was not waived because the issue regarding the marijuana pipe was completely separate. And as you noted, Your Honors, Mr. Sinclair did raise the issue of probable cause to search in the motion to suppress hearing. But the issue that was waived was narrowly constrained to probable cause to arrest for the gun that was later discovered in the car, not the marijuana pipe that was discovered before. Therefore, if there are no further questions, we ask that this court reverse Mr. Ackland's conviction for OVI or remand for a new trial as it's against the manifest weight of the evidence, and reverse the trial court's order denying the motion to suppress, as the trial court should have suppressed the marijuana. Thank you.
Thank you very much. Mr. Simon, you did a great job.
Thank you.
And we that is the last of our cases for today. Enjoy your day, and we will get a decision to you in a timely manner.
May I just say thank you to the court for permitting us to proceed over Zoom so that we can watch the eclipse yesterday and not get into the traffic.
Of course.